A major immigration law was officially passed in the United States today. And if you're a green card holder or someone hoping to become one, this development could change your future in ways many people are not prepared for. For some, this law opens doors that have been closed for years. For others, it introduces new responsibilities that cannot be ignored. Stay with me until the end, because what I'm about to explain may completely reshape how you plan your immigration journey. From this moment forward, welcome back to U.S. Policy Updates, your trusted source for timely and accurate U.S. immigration updates. Today's news is not speculation, not rumors, and not political debate. This law has already passed, and its effects are beginning immediately. Whether you currently hold a green card, are waiting for your priority date, or are just starting to explore your path to permanent residency, this legislation directly impacts you. In the next few minutes, I'll break down what has changed, who stands to benefit the most, who needs to be careful, and what steps you should consider taking right now. Let's begin with what many people will see as the biggest and most positive shift in years. The new law introduces a significantly streamlined processing system for employment-based green card applicants. For decades, skilled professionals, particularly from countries with high demand, have faced painfully long backlogs that felt endless. That frustration has been acknowledged at the federal level, and this law represents a direct response. Under the new rules, immigration authorities are now required to process most employment-based green card applications within a 180-day window. That alone marks a historic change in how the system operates. To make this possible, the law provides additional funding to hire more immigration officers, upgrade infrastructure, and fully modernize digital systems that have been outdated for years. For applicants on work visas like H-1B, or those whose priority dates have been stuck for what feels like a lifetime, this could dramatically reduce waiting periods. There is also a major expansion of premium processing. For the first time, green card applicants, not just temporary visa holders, may pay an additional fee to receive decisions in as little as 30 to 45 days. While implementation details are still being finalized, the message from lawmakers is clear. Backlog reduction is no longer optional. It is mandatory if you are watching from a country that has historically experienced the longest delays. This moment matters. Your patience is being acknowledged, and tangible action is finally being taken. However, as encouraging as this sounds, the law is not entirely without consequences. If you already hold a green card, this next part deserves your full attention. The new legislation introduces stricter standards surrounding green card maintenance, particularly for individuals who spend extended periods of time outside the United States. In the past, many permanent residents believed that returning once a year was enough to protect their status. Under the new framework, spending more than 6 months outside the country without a re-entry permit may trigger additional review. Absences of over 1 year could place permanent resident status at serious risk, unless strong ties to the United States can be clearly demonstrated. These ties include factors such as owning property, maintaining immediate family in the U.S., holding ongoing employment, and paying U.S. taxes. The goal is not to punish legitimate residents, but to ensure that green cards are being used for actual permanent residence, not as long-term travel documents. Alongside this change is a new requirement that all green card holders complete a brief, annual online confirmation of residence. The process takes only a few minutes, but missing it could result in unnecessary complications. If you live and work full-time in the United States, contribute to the economy, and build your life here, this change should not cause concern. The focus is on misuse, not compliance, staying organized, meeting deadlines, and maintaining clear ties to the U.S. will keep you protected now. Let's shift to one of the most impactful provisions of this law, especially for those working in healthcare. The legislation creates a fast-track green card pathway for healthcare professionals, including nurses, doctors, therapists, medical technicians, and home care workers. The United States is facing a severe healthcare workforce shortage, and this law directly addresses that reality. Under the new rules, qualifying healthcare workers currently employed in the U.S. on temporary visas may apply for permanent residency without going through the lengthy labor certification process that has historically caused major delays. An additional 25,000 green cards per year are now reserved exclusively for healthcare workers. Separate from existing caps, this significantly reduces competition and accelerates approval timelines. The law also includes strong worker protections. Employers are no longer permitted to use visa dependency as leverage for underpayment or unfair treatment. Fair wages and working conditions are now a legal requirement. tied directly to immigration eligibility for healthcare workers. This moment represents both opportunity and security. Preparation is key: gathering documentation, seeking legal guidance, and acting early can make a meaningful difference. While there is plenty of good news, the law also reinstates and strengthens public charge considerations, which has caused understandable concern. Immigration officers are now required to more closely evaluate whether applicants are financially self-sufficient. Extended use of certain public benefits may negatively affect applications or renewals, especially if those benefits were used for more than 12 months. Within a 3-year period, this does not mean that short-term assistance during emergencies will automatically disqualify someone. Medical crises, job loss, or family emergencies are still considered within context. What matters most is the overall financial picture, employment history, savings, and ability to support oneself. Without long-term reliance on public funds, for those preparing to apply, this is the time to focus on financial stability, even if that means starting with part-time work or building modest savings. One of the most emotional and historic components of this law involves individuals who were brought to the United States as children and grew up here for the first time. The law establishes a permanent pathway to legal residency for these individuals. Those who meet specific requirements related to education, service, and background checks may now apply directly for green cards. Rather than relying on temporary protections that require constant renewal, applications in this category will be prioritized with a target processing time of approximately 12 months. The law also allows eligible applicants to sponsor immediate family members, helping reunite families that have lived with uncertainty for decades. Financial assistance for application fees is included, recognizing the barriers many have faced due to their status for countless families. This represents closure, stability, and long overdue recognition. The legislation also brings major changes for entrepreneurs and investors. A new startup-focused immigration pathway allows founders to apply for green cards if their businesses demonstrate measurable economic impact. Requirements include raising a minimum amount of qualifying investment and creating a set number of full-time jobs. For U.S. workers, this eliminates the long-standing issue where successful founders were forced to leave due to lack of sponsorship options. Additionally, investment thresholds under the investor visa program have been adjusted in certain regions, making participation more accessible. While maintaining strong fraud protections, only legitimate businesses and verifiable investments qualify, protecting both applicants and the integrity of the system. For innovators and job creators, this law represents a long-awaited invitation to build and stay. Finally, there is one requirement that will affect every green card holder, without exception, beginning 6 months from now. All permanent residents will be subject to a biometric renewal process. Every 10 years, this includes updated fingerprints, photographs, and identity verification. While the process itself is brief, participation is mandatory. Alongside this change comes the introduction of a secure digital green card. In addition to your physical card, you'll have access to a protected digital version that can be used for employment, verification, travel, and identification. The system is designed to increase security, reduce fraud, and make everyday interactions smoother. Change can feel overwhelming, especially when it involves something as critical as immigration status, but at its core, this law is about modernization, accountability, and long-term stability. Staying informed, staying compliant, and taking action early are the keys to navigating what comes next. If you're watching this today, take a moment to reflect on where you stand in your journey. Whether you're already a permanent resident or still working toward that goal, this law shapes the road ahead. If this video helped you better understand where things truly stand, make sure you subscribe to US Policy Updates and turn on the bell for notifications. Stay prepared, because in immigration, timing and awareness make all the difference.